My name's Martin Burns. I work for RSS. I'm a member of the Chartered Institute. I have been for a very long time. I've recently discovered, just to give you a little bit more about my background, that I'm the longest serving full-time member of staff at RSS anywhere in the world. Is that a good thing? I don't know. 33 years and a bit. And I say full-time because I think there's a couple of part-time people who do consultancy work at RSS have been there a little bit longer than me, but I haven't seen them for a very long time, so I don't know. I'm not a surveyor, even though I've worked for the RSS for such a very long time. I've got to know a lot of surveyors. I've got to know a lot about surveying, all the different types of surveying, because the work I've been involved with at RSS since I started has always been about dispute resolution. I'm qualified as a lawyer, qualified as a barrister some time ago. I don't practice as a barrister, but it's a nice qualification to have. It's great when you put it up on a screen because the audience immediately goes quiet. I think I've got something sensible to say. That's when I turn up, of course. If anybody here is thinking of doing the bar course, it's a great course. It's probably the best presentation skills course you could ever do. And it also teaches you how to wing it and how to think on your feet, particularly when you go in front of an audience about 10 minutes later than you should have. I should have got to this place quicker because I've been here before. And this hotel's been around a long time, hasn't it?
Oh yes, we've used it a lot over the years.
For a long time.
Yeah.
And I tell you why, because it must be about 26 years ago, I was sitting where you were. And it was the first time somebody had mentioned this thing about adjudication to me. What he was talking about was this report by Sir Michael Latham. We're familiar with this, the history of the Latham report. Latham was commissioned by the Conservative government of the day to look into the construction industry. It's one of loads of reports that always say the same thing: the construction industry is in a mess. And kind of paraphrasing some of the words he used, he said, you know, the issue around disputes. Yeah, he said something along the lines of, you know, anything that can be done to make it better would be welcome. And it was Latham who introduced this concept of adjudication. Now, I'd been working at RSS for about 5 or 6 years before that. And I was really interested because for quite some time, I'd be getting telephone calls or letters. Remember letters? I used to get them in the post. That's how old, that's how long I've been working at RSS. I used to get letters, I used to get telephone calls, occasional email. It was just about coming in about that time, email, from people involved in contractual disputes who really felt disenfranchised from any method of resolving it, their disputes, particularly those involved in small disputes. When I say small, those days I'm talking probably £4,000, £5,000, £6,000, commensurate these days with maybe a bigger sum of money, but certainly disputes which meant they didn't feel able to resolve them through court. Any lawyers in the room? Probably some. There's probably some lawyers watching. They're not going to like me saying this. For goodness sake, don't go to lawyers, don't go to court, because courts are immensely costly. They take forever just to get in front of a judge, never mind to get something resolved. And so you have these poor people, you know, 26, 27 years ago when I was sitting here in the audience, who were phoning me, who had these disputes. They didn't feel they could go to court because it just cost too much to go to court. It also took so long to get their disputes resolved. Now, they were using standard forms of contract in the day, JCT forms, those sorts of things, had arbitration clauses in them. And back in the day, arbitration was quite popular, particularly with larger disputes on construction contracts, less so now. But even then, they felt they couldn't use arbitration because arbitration had quite a bit of a bad reputation back in the day, back in the sort of early mid-90s, got a bad reputation because it was almost like going to court. Certainly took just about as long. And what they got was, you know, arbitrators who were dealing with disputes based on evidence only, almost like a trial process in itself. And it cost a long time and arbitrations were lasting long. So these people I were talking to were, if you like, and I use that word again, disenfranchised from having their disputes resolved. Disputes where the monies may have been smallish, but was certainly very important to them. And that's why when I was sitting in the audience where you are now, I was interested because the speaker that day, who turned up on time, was a chap called Michael Milne. You know Michael?
Oh, yeah.
Michael is a charter surveyor. He's still around. He's a good chap. He's been retired a long time now. And Michael was also a barrister as well. And Michael was talking about this Latham report and about this proposal in Latham's report for this thing called adjudication. And it sounded like the right fix, a quick, cheap way of resolving disputes that didn't involve all this sort of formality, that didn't involve all this sort of process of going to court or arbitration. It was quick. Somebody who was a subject matter expert could be appointed, could go in there, make their investigations, listen to what the party's saying, come up with an answer very quick. And the timescale was 28 days from the day they were seized with it. And I thought, this is great. This is what RCS ought to be getting involved in. We need to be alert to this process called adjudication because it's bloody good. Sorry, it's good. And I went back to my bosses at RCS. I could talk about it now. Yeah, it's not been around for a long time at RSS. Con Lennon, got on with him very well. And I said to Con, RSS needs to get involved in this adjudication. We need to set up a process where we can facilitate the appointment of adjudicators to resolve these contractual disputes when this act comes into force, which will be in 8 or 9 months' time. And Con, he wasn't, I wouldn't say he wasn't interested, he wasn't convinced. And because what I was suggesting would, of course, involve investment in my time, probably some time, money and resource on the part of RSS to set up a panel of adjudicators, to put the administrative processes in place, and of course, all the soft services that go around that, query handling, all of that. And Con said, look, I'm not convinced, but you seem to be convinced, Martin. So if you want to spend a little bit of your time putting all this together, do it. But tell you what we'll do, he said, why don't we cancel your salary? You know, that woke me up. I said, why don't we cancel your salary and we charge for each appointment made and you get that as your salary? I thought, oh, no, I'm not doing that. I'm not taking that risk. You know, I think this has got legs, but, you know, I'm not 100% on it. Oh, I wish I had. I wish I had. You know, RSS currently, by the way, points of like 1,200 adjudicators a time. And the nomination fee is £425. So work that out. It's not a bad sum, is it? So I would have liked that. To be fair to Carl and to RSS, I eventually managed to persuade them this thing had legs, and it was good for the industry. It was good for the construction industry because it was enabling charter surveyors to get involved in resolving disputes, using their technical expertise, their technical knowledge, getting in there, resolving these disputes quickly. Smallish disputes, cost-effective resolution. Great. So RSS set up its first panel of adjudicators. We set up a training course. I'm going to drop some more names. The local guy actually helped me, Michael Taylor, who's with Vision Partners for a long time. And he became honorary secretary at RSS. And Michael really led the first training course for adjudicators. You notice I'm not paying any attention to my slides. You can follow the slides later. There's one or two things I'll draw on the slides, but they're basically for your information about the low value scheme. Michael and a chap called Tony Ensom and myself trained the first tranche of adjudicators, set up the RSS panel. Of course, there were other organisations doing the same thing, you know, because they thought this is a good thing to get into, the ICE, REBA, Chartered Institute of Arbitrators, others. And then 1st of May 1998 came along. That's an important day because that's the day that the Construction Act, properly known as the Housing Grants Construction Regeneration Act 1996, came into force. And that gave effect to the Latham report, or Michael Latham's proposals for adjudication, section 108. And section 108 says that all construction contracts should provide for the resolution of disputes through a 28-day process called adjudication. And through regulation, it allowed parties to either name the body that would appoint their adjudicator in their contracts, or to go to any organisation that held itself out has been able to nominate adjudicators. And RSS was there, ready. We had that panel, we had the soft services and the admin already in place. 1st of May 1998, 1st of June 98, nothing's happening. 1st of July, nothing. And I was starting to think it was a good idea not to accept that offer. It wasn't until around about the beginning of October that we got our first call from somebody said, oh, we heard about this adjudication thing. Can you nominate an adjudicator? I was on it like a flash. And we appointed our first adjudicator in September 1998. By the end of the year, we'd nominated 23. And then there was some case law, which I don't know if you know, familiar with the MAP and Morrison. Yeah, up until that point, you know, people were thinking, well, we've got this adjudication decision, don't like it, we'll ignore it because it says it's just temporarily binding. But what MAP and Morrison did, of course, is it proved that you can't ignore the adjudicator's decision. Then we had Outwing and Randall, which added more meat to the bones on that and said, if a party has to enforce the adjudicator's decision, the other party pays the cost. Great, lots of stuff. And that following year, RSS appointed 350 adjudicators. And the following year, 800, the following year, 1,000. And it's been around about 1,000, 1,100, 1,200. I think the most in the year has been 1,400. So adjudication has proven to be immensely popular. And it's been around now for over a quarter of a century. And I've been very much pleased that RSS has been at the forefront of that. RSS is a nominating body, like a lot of other organisations, but we're responsible for 70% of all adjudicator nominations in the UK. That's a big number. Let's move on a few years. They always say, don't let the lawyers get hold of something, don't they? Because adjudication is this quick fix. It's a nice, simple process, or it used to be. And in 2017, the government department, BAYS, undertook a consultation. You might have been involved in that consultation, I don't know. But the consultation was driven by what I was told by the people at BAYS. I don't want to use the complaints, but certainly suggestions that adjudication had now got to the point where it was too complex in terms of its process and too costly for many organisations to businesses to use. And that BAYS consultation response, which I encourage you to read, it was very interesting, suggested that parties were telling the government that if a dispute involved less than £50,000, it simply wasn't worth taking to adjudication. So you can imagine, I felt quite sad about that, because this was a process that I was involved with at the beginning. I saw it as a potential solution, particularly to SMEs, but not just SMEs. Big companies also have smaller disputes that, you know, it's too costly to take to court. Following that consultation by BAYS, move on another couple of years, and I find myself involved with the Construction Industry Council, the CIC, sitting on a board. It's called the ADR Management Board, the Alternative Dispute Resolution Management Board, chaired by a man called Niall Lawless. Anyone know Niall? Yeah, Niall's you don't mess with Niall. He's from Northern Ireland, Ross Trevor. Beautiful place, but he's not beautiful. He's an ugly beast of a man. And he has this real strong Northern Ireland accent. He's frightening, but I like him and I got on with him. And at one of these board meetings, Niall said, or asked the question, look, this board is looking to have a project. This board is looking to have a project, and we're keen for some suggestions from members of the board. And I put up my hand. I said, well, why doesn't the Construction Industry Council do something about this increasing complexity that's happening around adjudication, and try and find a way to give small businesses and those involved in small disputes access once again to this process. This process is fabulous. You know, there's 1,200 odd cases a year just going through RSCS. But what we're seeing is big disputes, big businesses, lots of lawyers involved. What we're not seeing are the smaller businesses who really, you know, ought to have the facility to use adjudication. And so the Construction Industry Council decided what it would do then is ask me to chair a working party to develop a framework for adjudication that was compliant with the Construction Act, but would enable small businesses and those involved in smaller disputes to once again use adjudication. That was an easy ask, wasn't it? What are my slides saying? Well, that's about the consultation. Do you want to move on to that, please, Mark?
Yeah.
See where we are with this. So the Construction Industry Council asked me to chair a working party. I brought onto my working party a practicing adjudicator, a chap called Peter Vinden.
Oh yeah, good guy.
And Peter's a good egg. He's a very experienced adjudicator. I like him also because he doesn't just adjudicate, he acts as a mediator, he acts as arbitrator. He's a good businessman. He has a good head on him. Also brought into the working party a chap called Christian Charles. Christian is a lawyer with Fladgate. The reason I brought him in is because Christian, also a member of that particular board at the CIC, he's a lawyer who represents parties quite often in disputes. So he can look at it from that perspective. So an adjudicator, and I had Christian. I also consulted on a regular basis with a chap called Matt Malloy. Matt is actually now chairman of the CIC ADR. So he took over from Niall Lawless a couple of years ago. And we developed a framework which became the Construction Industry Council Low Value Dispute Model Adjudication Procedure. That's easy, isn't it? LVD MAP. And the idea for the LVD MAP was that this would be a procedure that could be adopted by adjudicators, which would give parties involved in low value disputes a simple and easy to access form of adjudication that complied with the Act. What it was about was limiting the amount of documents, limiting the amount of fees. So we set the fees for the adjudicator, and we set a threshold. We had no end of discussions about what we meant by low value dispute. And quite frankly, we still don't agree on it. But we had to kind of come up with some threshold. And at the first instance, we decided that a low value dispute would, on the face of it, be any dispute where the monies involved didn't exceed £50,000. And I understand the reason why we picked that number was because that was the number that was cited in the government report on the consultation. So there's our threshold. But we also described a low value dispute as something that's not overcomplicated, something that's not multi-issued. It doesn't involve, many complex legal issues. It's a simple, straightforward dispute that can be disposed of quickly within 28 days with a limited amount of evidence, and not this sort of process where a referral is made and then a response and then a reply and then a rejoinder and a surrejoinder and God knows, back and forth. That it was simply a referral, a response, some interrogation by the adjudicator who may ask for more information, and an answer to the question. That was what it was about. Should we? Quite frankly, I've forgotten what slides I put up there. So Mark asked me a while, can we have some slides? And so that's what we did. We set out to develop a streamlined procedure. When I say we, it was the Construction Industry Council's model adjudication procedure, not the RSCS. And we were looking to really, as I say, re-enfranchise parties back into adjudication. People, in my job, I have a lovely job now because I talk often to people in government and industry leaders, and I get a real sense of kind of direction of travel. I'm talking to people within the government. It was quite clear that they were very fond of this idea of developing an adjudication procedure which would allow SMEs in particular to gain access to adjudication. I just put in the bottom there just a reminder to myself, it's not just for SMEs, by the way, it's for small disputes. We had an adjudicator appointed under this procedure through RICS, and they were minded to resign from the appointment because they found that one of the parties, or the party who was issuing the referral, was actually quite a big business, you know, very moneyed. I thought, this is not for big businesses, this is for small businesses. And I said, no, it's not, it's for small disputes. And they were arguing for about £14,000, which just wasn't worth going to court for. And it wasn't worth arbitrating for. And using the adjudication normally, it probably wouldn't be worth using adjudication. But using this procedure that the CIC has developed would allow them to get an answer and get a result, and a binding result at that. Mark?
Next one.
By the way, you know, if you've got any questions, put your hand up, or you know, feel free to butt in.
Sorry, can I?
Sir.
I should say, it said on the previous slide about the fees. How do you work out? How do the adjudicator work out his fees?
Oh, I'll come to that in a moment.
Oh, right. Okay.
Yeah.
You got me jumping at that now, haven't you?
Just working out how long it took before somebody mentioned fees.
Yeah.
Yeah, pretty good.
Just a point, you talk about 50,000, which
Yes.
is sort of, as a building surveyor, that's much more my domain. Is that's not the whole contract, that's the amount in dispute? is
Yeah.
it?
Yeah.
However you assess that, because that could vary, and that could be quite interesting. But someone makes that arbitrary decision, we're in dispute, as you say, 14,000 or something like that, and then presumably you'll stay within those parameters.
Yeah. The way adjudication works then is I'm in dispute with you.
Yep.
And what I do in order to start adjudication is I issue you with a notice of adjudication. That notice is saying to you, right, it's my intention now to take this dispute with you to an independent adjudicator. And in that notice, I have to say who I am, who you are, what the contract is, what the dispute's about, and what the remedy is that I'm seeking. And that would be a sum of money. And that's
It has to be quite money.
it always is. You tell me
90%, isn't it?
99%.
Yeah.
It's
So the job's not going to be finished necessarily, so
Oh, no.
no, but
No.
you clear, all right.
yeah. It's always about money.
So actually, it could be quite a large job.
Oh yeah.
Yeah.
That
Yeah.
example I cited a moment or two ago, where the adjudicator was minded to resign, that was a huge job. I think it was a multi-million-pound job, but the dispute was only about £14,000.
Right.
So, and it's a good question because it is difficult.
Yeah.
In adjudications, by the way, you can't, in your response, counterclaim. If you want to adjudicate a counterclaim, basically you have to start another adjudication.
On that one issue, it
Mm.
could be another issue that comes up later on, or something like that.
Another adjudication.
You would have carte blanche to go and, you
Yeah.
could, so, yeah. I
And
see.
it's often the case, we see it, that there are multiple adjudications on a project or on a contract.
Right. And they're all standalone, separate
Yeah.
issues, right?
Yeah.
Brilliant.
Where was I?
Fees.
Fees. No, I was going to come to fees. Yes, it was just mentioned fees. The procedure itself, and what I'm getting from these questions is that I'm talking to an audience maybe that's including people who are not fully familiar with adjudication. So do you mind if I just spend a couple of minutes just running through the process quickly? So the Construction Act 1996, Section 108, says that all construction contracts, and construction contracts, by the way, are defined in the Act itself. It says this is what a construction contract is. All construction contracts must include the facility for the resolution of disputes through 28-day process of adjudication by an independent adjudicator. Now, if a contract doesn't comply with the Act and doesn't include those provisions, then they're implied. And that implied term is actually set out in a statutory instrument or a regulation called the Scheme for Construction Contracts Regulation 1998. Yeah. And the scheme for construction contracts, we all call the scheme, is effectively an adjudication clause. It just runs through the process of adjudication. The way it works is that, I'll just explain, I issue you a notice and I say we're going to adjudicate and I believe you owe me £50,000. That's what I'm claiming off you. I'd be quite crafty about it as well. I say £50,000 or so much of this, or whatever sum the adjudicator decides, because the adjudicator might say, actually, he doesn't owe you 50, he owes you 48. So if I've asked for 50, I've asked the wrong question. So just to cover my back, I say the claim is for £50,000 or such sum as the adjudicator decides. Okay. Once I've issued that notice on you, I have 7 days to give the dispute to the adjudicator. You know, my bundle, what it is that I'm the evidence I'm relying on to support my case. I don't know who the adjudicator is, of course. In all my days, I've never seen an adjudicator named in the contract, by the way. It doesn't work, it simply doesn't work because of the timescales involved. So from the day I've issued this notice of adjudication, I've now got 7 days to hand the dispute to the adjudicator. Now, what tends to happen then is me or my professional representative, you know, a lawyer or a surveyor, hopefully a surveyor, would then apply to what's called an A and B, an adjudicator nominating body. And there's several of these around. When adjudication started, there was about 40. But now there's probably about 5 or 6, maybe 7 that regularly are used by parties. And they're used because parties trust them and they get good adjudicators. RSS is one of those bodies. Now, RSS might actually be named in the contract. So JCT often names RSS as the body to go to if you want your adjudicator. If it doesn't, you can go to anybody you like. RSS, once it receives the request from me, saying, I want an adjudicator, RSS then has 5 days to tell you who the adjudicator is. So there's 2 timetables running here. There's one where from the notice to the time I've got to give the adjudicator 7 days. From the time I apply to RSS to they tell me who the adjudicator is, 5 days. We thought you'd left. We were talking about you. So what RSS tends to do is nominate that adjudicator well within the 5 days to give some breathing space for the party for me to refer to the adjudicator. So I'm then told, say on day 3, by the wonderful Mushtaq Ahmed. You've got to be introduced to Mushtaq. He works for me. He's the guy who does all the nominations. He's the guy who decides who on the panel is going to get appointed. And Mushtaq would tell me then, your adjudicator is Mark.
Oh God.
That's what I think. Oh God, no, I don't. Great, we got a good adjudicator. I then, within that 7-day period, have to then refer the dispute to Mark. That's called a referral notice, and that effectively is the point at which the adjudicator has the jurisdiction from that point to decide the dispute. He then has 28 days to make that decision. That 28 days can be extended by up to 14 days with my permission. And it can be extended beyond that with the permission of both parties. That's the way the Act is set out. What has tended to happen, and why I was talking about the over complexity of adjudication since it first came into force, is that too many disputes now go well beyond the 28 days, well beyond the 35, into 60, 70, 80 days. And that builds up the costs, of course, particularly if you're employing lawyers to kind of put in your representations. And there has been, and I've seen it in particular places where that kind of notice of adjudication, referral, response to the referral, reply, rejoinder, so that has gone on And that just adds more time and more complexity. So the adjudicator then makes a decision within the, say, the 28 days. That decision is binding in the interim. And what Mackup and Morris, in that case I cited a moment or two ago, what that said is that what that means is it's binding. You can't ignore it. So if the adjudicator then says you have to give me the £50,000, even if then you say, well, I'm going to court because this needs further investigation than the 28-day period would allow, you have to pay me the £50,000 in the interim. Now, it could be we go to court and the court overturns that and I have to give it back. That's how it works. Now, it's worked successfully for a long time, as I say, but it has increasingly got complicated, which is why the CIC decided to introduce this simpler form. So how does one get to use this simple form of adjudication? Well, the procedure itself says that parties can actually set out in their contract that in the case of an adjudication, and they might sort of put some parameters around that, where the dispute is less than a certain amount, then the adjudication will be undertaken using the CIC's low value procedure. And I'll go a little bit more detail about the low value procedure, including the fees bit. Don't worry, it's coming in a moment or two. It could be that a dispute has arisen. The parties see that actually this is relatively straightforward. We're not going to agree on it. We need to get it adjudicated. Why don't we have this adjudication procedure used under the CIC's low value process? Because it's quicker and cost effective. The reality, I've worked in dispute resolution for 33 years. If you have two people in a dispute, usually one of them's not interested. So trying to get that agreement in reality is probably not going to happen. But you never know. The third is that where there is no agreement by the parties, either in their contract or after the dispute has arisen, to use the low value process, then one of them can ask the adjudicator, Mr. Adjudicator, Mr. Thomas, we'd like you to follow this procedure because it's more cost effective for us and we think this dispute lends itself to being resolved using this process. And then it's up to the adjudicator. It's his choice then. He would look at the thing in front of him and decide, well, yes, I think this is something I can follow the CIC's procedure. Or he might say, I'm sorry, I think this needs more investigation than that procedure would allow, and I need more time and I need more evidence. We probably need an expert witness to come in on this point, whatever it might be.
Would that be too late to raise that issue? Because Mr. Thomas might be on the main panel, but not on the low value dispute panel. That's
a good question, because this is probably going to confuse the rest of the audience here. What was about the low value? I've been arguing, and I think I'm going to get my way on this at RSS, that somebody who's on the so-called low value panel of adjudicators is a proper adjudicator.
Thank you.
They've gone through a diploma. They've gone through a diploma, 18-month. They've passed all of that. There's no such thing as two tiers. If they're not good enough to do adjudication of any kind, they're not good enough to do the low value. If they're good enough to do the low value, they're good enough to do the others. That's my argument. So I'm pressing that point home.
Good.
Another slide. Let's see what it brings up.
Mark, just on that last point, as many people in the room will know, you get all the same stuff in the small adjudications that you occasionally get. You've still got the basis of the contract, the basis of the dispute, the basis of the breach, the remedy that follows that. So you've still got to do all the same processes, whether or not somebody's chasing down 25,000, 250,000 or 2.5 million. So it's all the same stuff, isn't it? It may get more pages, but often you still have to go through the same processes.
I think sometimes, Mark, it's more
difficult.
work because you're sometimes explaining it to a layperson, shall I say, rather than the national.
Perversely,
this all goes to this argument, or not argument, long debate and discussion we had at the Construction Industry Council as to what amounts to a low value dispute. And it's not just about the money.
Mm.
It's about the issue
Complexity.
and complexity.
Mm.
And the adjudicator has to decide, is this of sufficient simplicity, which is the opposite to complexity, that I can deal with it using this process and dispose of it within 28 days without having piles and piles of paperwork and correspondence and wheelbarrowfuls of lever arch files. I was talking to Jonathan Cope, another adjudicator you may have heard, and Jonathan was telling me the analogy he paints is that sometimes he's appointed as an adjudicator, and one of the parties wheels up with a wheelbarrow full of lever arch files and says, "Oh, case is in there somewhere, go find it." That's not good, is it?
No.
But that means that the adjudicator is going to have to spend more time, and if that's the case, then it's not a dispute that would lend itself to this procedure. I mentioned the scheme for construction contracts. Scheme is regulation, it's the law. The scheme for construction contracts is the law. It sets out how adjudication must and should work, and the obligations of the adjudicator, the obligations of the parties. And here's an analogy. And what we were finding at the CIC is we were appointing adjudicators to use this low value process. And the adjudicator was coming back to us and said, the respondent's not playing ball. They said they haven't agreed to use it. And that meant there was a question that needed to be answered. The question being, does the adjudicator need permission of the respondent on both parties, actually, before they can use this procedure? We looked at this at the CIC, and it was about this time last year that Matt Malloy, who was chair of the ADR board, asked me to chair a second working party comprised of the same people to review the CIC procedure and see if we could provide clarity around this issue and also the issue around fees. Come into it, don't worry. And one or two other things. I said to Matt, look, the reality of it was, you've all been there. You're in a meeting. There's maybe 12 people around a table, and you just phase out for about 2 or 3 minutes. You're not listening, are you? That's happens to all of us. The last 2 minutes of what happened in the meeting, you're just not. You wonder what's going on, and then you're playing catch up, and then someone calls your name, and Matt Malloy said something to me like, "Is that okay with you, Martin?" And of course, my immediate response was, "Yeah." That's how I volunteered to chair the second working party. You've all been there, I know you must have been there sometime. And we were asked to clarify certain points, particularly around the whether the parties need to both give permission to the adjudicator to follow this. But what we found as we went through the CIC procedure is it was a bit legalese. The language of it wasn't really lending itself to the audience that we were hoping would use it, which is, small businesses, contractors, that kind of thing. So we effectively went through it and simplified it as best we can. And we also looked at, well, let's go back to this guy who said, this adjudicator, I think I'm going to have to resign because the respondent said that they haven't agreed to use this process. We looked at this case, and this was a case where the adjudicator had been appointed under Section 108 of the Act. It was Construction Act compliant. And one of the parties said, if you appoint an adjudicator, can you appoint an adjudicator who is prepared and able to adjudicate using the CIC's low value scheme? So it was a proper Construction Act compliant adjudication. So then we looked at, well, where in the Act or the scheme does it say that the parties have to agree on the procedure that the adjudicator is going to adopt for that adjudication? I challenge you all, look, if you can find it, tell me. I can't find it, and I've looked and looked and looked. So we looked to the scheme, and there's two important pieces of the scheme.
control.
The Scheme for Construction Contracts Regulations, if you're not familiar with it, you could just easily download it. It's only a page, I think. And this is the law. And section 12B of the Scheme for Construction Contracts says that the adjudicator has a legal duty to avoid incurring unnecessary expense. Now, I take that to mean quite a lot of things, and some adjudicators might disagree with me. So sorry, Mark, if you did. But I take that to mean that an adjudicator needs to look at the dispute that's in front of them and make sure that whatever procedure, however they follow, whatever fee scale they set for that adjudication, means that the parties don't incur necessary expense. It means also that the adjudicator has to manage this process. And I've had a few to and fro, shall we say, with some adjudicators recently. Any adjudicators from Scotland? Right. All the people I've been arguing with are from Scotland. Adjudicators. Because they argue that they really need to give the parties every opportunity to put their case. And I said, no, you don't. You only have to do what is reasonable. You don't have to, allow the referral, the response, reply, rejoin this. You don't have to do that. All you have to do, and if you do that, and you've got a simple dispute in front of you, then you're breaching section 12B because you're incurring additional expense and it's not needed. So the point I'm making here is that there's a duty on adjudicators as a starting point to deal with the beast that's in front of them in a way that avoids incurring unnecessary expense. Section 13 is a bit longer, and I haven't set out the whole of section 13 there, but it's worth having a look. But the important thing about section 13, it says that the adjudicator shall, there's any lawyers in here that know what the word shall means, it doesn't mean may or might or could if they wanted to, shall, the adjudicator shall decide the procedure to adopt for the adjudication that's in front of them. It doesn't say the adjudicator needs to consult with the parties, get their agreement, and then adopt a procedure. It says the adjudicator shall decide procedure. And when the adjudicators deciding the procedure they're going to adopt for an adjudication, they have to have regard to section 12B. That's a fact.
Yeah.
So in reality then, you're appointed as an adjudicator. One of the parties says, I want you to consider adjudicating this and adopt the procedure, that is the low valued procedure published by the Construction Industry Council. And the respondent says, I'm not interested, I haven't agreed to this. It's the adjudicator's decision then. They need to make a judgment call. Is this an adjudication that lends itself to using this simplified procedure? And if the adjudicator decides it, then the respondent can either play ball or not, and the adjudicator can get on, make a decision, giving the respondent every opportunity to participate, but the adjudicator doesn't need them to participate. Just get on with it. So,
just a question: if the referring party puts a request into the A and B to use this procedure, put an adjudicator to use this because they've got a less than 50, say,
yeah,
and the adjudicator says, "Well, I've had a look at it, and no, doesn't lend itself." Just I'm just wondering, what if the referring party is not happy with that? I appreciate it's the adjudicator's discretion, so I'm not going to go into like get that it's his call. But if they've got a low value one, if they carry on and they refer that dispute, then they're going to roll the dice on potentially what's going to cost them, where the whole point for them was to try and keep it low value. So can they go back to the A and B and say, can you find me an adjudicator that will? Or what happens
in practical terms, that's happened.
Is it?
Yeah. What I've been asked to do now, I had one of those phase out moments, and Matt Malloy says, "You're right, Martin." Yes, I volunteered now to head a working party that's going to look at setting guidance for what adjudicators should do. And our thinking around this is that if the adjudicator decides that this actually needs a bit more intensive investigation than this procedure would allow, then they don't simply abandon the LVD MAP procedure. they draw on it as much as they can, add a little bit more time, negotiate a higher fee than they would that's set under the scheme. But again, it's having regard to 12B, not incur extra costs. I think that's the best way around that. Should we have another slide to see what it says?
Oh, crikey. See if I can move this.
Oh, this is all around the timescale. So we've been talking about this procedure, but I haven't really told you what it is. The other thing I haven't told you is, you know, this second working party I was asked to, that simplified it, that clarified this point around whether the adjudicator needs the parties to permit them to get on with it. What it also did is it raised the threshold. It raised the threshold to £100,000. So if there's a dispute that's £100,000 or less, not 50 now, so it's increased that. We did that because TEXA, the Technology Courts Solicitors Association, also produce a low value adjudication scheme, and their threshold is 100,000. So we thought, well, let's not confuse everybody. Let's kind of keep it simple and go for that.
Martin, when did that come applicable? From what date?
That's May this year. So we had a launch event at the CIC in May this year, and that's when it was published. This just goes through the timetable and procedure. I don't mean to go into a lot of detail. It's there. Are we sharing these slides, by the way?
Yes, they'll be sent to everybody retrospectively. Okay.
So that's.
Well, sorry, one quick question. On the response, it says no later than 14 days. Can it be sooner? Can the adjudicator ask it to be within 7?
It says unless the adjudicator directs otherwise.
So he could say 7. You might say, well, that's a bit quick.
Sorry?
He could say 7 and not 14.
He could, yeah.
I think I might be wrong on this. I think that's been updated in the second edition of the LVD MAP, and it has changed to 7 and then 14. So adjudicator's got 14 days. I think, but
so ignore that timetable. We'll send slides. We'll send some data slides.
you still get state at the end.
You're quite right. And again, another good reason for me saying just ignore that for now. The idea is that it limits the amount of paperwork that the adjudicator has to assess and look at. It's done on a paper exercise only, so it's not, you know, like a formal hearing. The adjudicator. What's the next slide? This one's wrong. We don't want to keep looking at this one too long.
That's the last one.
That's the last slide I sent.
Oh, hang on.
I should think so.
Well, weirdly, it's not. Sorry, IT issues. It's not moving.
It's not just me then.
Oh, hang on. Yep. Okay. Right.
Here we go.
Right. So
we move from this.
that one.
Yeah, so it's a documents only basis. The whole thing is really aimed at trying to streamline and structure the adjudication, keep people focused, and not allow sort of all sorts of stuff coming in left, right, and centre. And the adjudicator, as I say, the adjudicator can proceed with the adjudication even if one of the parties says, "I'm not playing ball. You know, I don't like this." Because it's not in their interest. And it often makes me wonder, because this process is designed not just to help the referring parties, to help both of them get their dispute resolved quickly and cheaply. If somebody starts an adjudication, the other party's bound into it. You can't ignore it. You're stuck with it. So if you then start messing about saying, "I'm not going to comply, I want this adjudicator to look at this wheelbarrow full of files I've got," then that person is not doing themselves, or if they're acting for parties, they're not doing the parties any favours, because what they're doing is adding to the costs. This simple form of adjudication is cheaper for both parties, not just the referring party. Are you struggling there, Mark?
Yeah, I don't know why. I'm not getting the any response out of the keyboard. I mean, it just did, as you saw, but you know, it's not. It's freezing on me.
And it had that lovely slide with all the fees up. Yeah.
That's a mystery, then, isn't it?
Well, I'll try and work from memory. This process is not going to make adjudicators very rich. some very experienced adjudicators I know might not like to hear that. But I tell you what it is, it's good grounding for people who have just come through a training program. It's a good way to get adjudicators experienced. When I say it's not going to make adjudicators rich, that's because it sets a cap on the amount of fees that the adjudicator can earn to a maximum of £5,000 to be divided between each party. And again, that was changed from 6,000. You don't like that, I can imagine that.
I've just been corrected on one of those.
Yeah, and the reason for that again is to make it consistent with the adjudication simplified form that is produced by the TEXAC. So the parties know from the very start that the maximum that's going to be paid to the adjudicator in fees is £5,000, and that it's to be divided equally between them. Now, anybody here familiar with adjudication generally, we know that adjudications can cost far more than £5,000. And what we're trying to do here is provide clarity around the process itself, the timetable, and how much it's going to cost, to try and bring parties in and say, look, don't be afraid of it, because it's not this complicated legal process. It's a simple, straightforward. It's not going to stop you getting legal professional advice, but there are occasions where you can cut down on the amount that you need of that legal professional advice. It's got a nice timetable and structure. The language is nice and easy, so it's not set out in legalese. And you know what you're going to pay for it at the end of the day. There you are. That's the fee scale that we came up with. Again, one of the longest meetings I've ever sat through. Even longer than it took Mark to find that slide.
Yes.
This is the result of kind of a lot of discussion, not just with the working party, but coming back to the board itself and working through, well, what is the correct. Now, what is the amount I think people would accept, both adjudicators, because we want adjudicators to feel that they're getting a reasonable remuneration for the work, keeping it simple so they're not having to deal with barrow loads of paperwork, but also making it attractive to parties involved in the lower end value disputes.
Sorry, Martin, a couple of questions on that for me. So the dispute can be up to 100 grand on that fee scale. So you can, it's not just limited to 50.
Sorry, I'm going to answer your question about.
It's not limited to the 50 grand you talked about earlier.
It's now 100.
Yeah.
So it's moved to 100. That was from May this year.
Right, and it's split equally between the two parties, whereas it's not the adjudicator to decide where his fee goes. It's actually split.
The adjudicator accepts the appointment on the basis that they're going to decide that both parties pay, and both parties. That's the way it works.
I mean, under the Act, he's got to have the right to decide who shall pay in any event, doesn't he?
Yeah.
So it isn't automatically 50-50. It's for the adjudicator under his powers to determine.
Mark's corrected me. It's a good job he's here. You get lots of bad information. Yeah, so the adjudicator decides. But what the parties know is that the maximum they could outlay in any case is 5. Yeah. These are the headline changes, by the way, from May this year when the second edition was published. It clarified that both parties' consent is not necessarily required where the scheme applies. So just to clarify what I'm saying there, the parties are parties to a construction contract as defined in the Section 108 of the Construction Act. One of the parties then applies for the appointment of an adjudicator, and the adjudicator is going to conduct the adjudication in accordance with the scheme for construction contracts. That's the basic, that's the process that they will follow. The adjudicator then exercise their obligation to avoid unnecessary costs, but also use their power. And indeed, it's not just the power at section 13. Section 13 is both a power and an obligation to adopt a procedure that's relevant to the dispute before. And as I say, we raised and increased the threshold from 50,000 to 100,000. Note, by the way, if a dispute's over 100,000, it's still, we talked about the small dispute being very complicated. You can have a big dispute over £100,000. It's not. It's quite simple. So what we've said also is that parties can use it to resolve disputes over £100,000. In those cases, the fee with the adjudicator needs to be negotiated.
Excellent.
That's about it, I think.
When we did the adjudication course, the diploma, Matt went out of his way to say that whilst the fees are capped at 5k now, the time you spend on it isn't capped because you've got to do the same job that you do otherwise. So you will get some that are simple that you'll make a couple of quid out of, and there'll be some where you spend more than you would ordinarily charge.
Yeah, and
there'll be swings and roundabouts.
Who would want to be an adjudicator in those days? Yeah.
But that, I suppose, that reinforces the fact that you need to make an assessment as to the complexity or simplicity.
You need to make that judgment. Also, as an adjudicator, you need to manage the adjudication. So if you've made that decision as an adjudicator, this is something straightforward. Unless the parties come up with something that really makes you think, well, hang on a minute, there's more to this than first met the eye. You need to manage the adjudication in a way that gets it through to 28 days with as minimum effort as you're able to put into it. Should we go to?
Yeah, Martin, I'm just conscious of time because obviously
I was late, yes.
Oh, crikey, and it's well, I have no idea what Sunday. IT. Can I just link back to the to what Roger just asked there, because one of the things that we put on the flyer, and which you and I discussed about 3 weeks ago, was that you would also talk about how people would become adjudicators. And obviously, it's always a hot topic, particularly with the people in the room here. And Roger has alluded to the RICS's diploma. I wondered if you'd like to just say something about that side of things before we then take general questions.
Any aspiring adjudicators? Oh, wow. Anybody currently?
Well, yeah, I'm on low value panel, obviously, but not the main one. But I'm not going to get into that now.
Yeah, let's not. We haven't got enough time. This is, I think this is an interesting moment in time in terms of the panel itself, because historically what we've looked at is, well, how many cases are we going to be asked to appoint adjudicators on in a given year? You know, it's pretty easy to guess how many adjudicators, because we look at the previous years. You know, if you look at trends, how many adjudicators do we need to fulfill that? That's the starting point. And what we also find is that we have adjudicators who are retiring, moving off the panel, so we need to replace them. And that's like a moving feast. It's happening all the time. There's quite a few of our adjudicators who are no longer as young as they used to be. And we need to know, and there's kind of a big tranche of them as well, if you look at the demographic. And the fear is that if they all went at once, we're in trouble. So we need to keep feeding in all of the time. We owe a duty of care at RICS to make sure that any adjudicators we appoint are really fit for purpose. And that's why we introduced the diploma as a kind of a benchmark level. The diploma actually is good for a number of reasons, because it teaches you a whole raft of skills and knowledge around adjudication. It's not just how to be an adjudicator. Using that helps you represent partners. It helps you in all sorts of things. It's an excellent course. It's the benchmark course to get onto the RSS panel. There's others who follow a similar course of training, say with the Chartered Institute of Arbitrators, and we have an exemptions policy then that allows them to go through and be exempt from most of the diploma, but they still have to undertake certain elements. So say you've done the diploma, what do you need to be next? Well, you have to be a little bit patient next, because your time will come. If you're persistent and you want to be an adjudicator on the panel, then if you, and I use this word persistent, persistent also means don't just sit there and wait. Do what you can. Do the low value adjudications. We're also providing adjudication services now on consumer disputes. Did you know that? Yeah, we just won a contract with Which, the consumer body. And it's to provide adjudications on disputes between those involved in the building trade and consumers. But what it allows is people who are coming through, who are getting trained through the deployment of the cases to adjudicate those disputes. Not going to pay a lot, but it's actually going to give them.
I gave up on the application form.
It will give them. It will give them add to their CV, and if you've got it on your CV, then that's a good thing to have when you want to then say, right, I want to be next in line for the next reassessment. And RSS then call people and say, okay, we need adjudicators here, there, and we invite them along to kind of an assessment program and an interview. And they'll be interviewed by a 3-panel interview. The first head of the interview panel is a serious adjudicator, should we say, a very experienced, somebody like Matt. Do you do interview panels?
I do for the expert witness, but I'm not for the adjudications.
Well, certainly experienced adjudicators will be the chair of the panel. Then you will have maybe a lawyer who's involved in adjudication sitting alongside them. And then we have what's called a lay person. And they tend to just make sure things work out right. And they're often fed questions about conflicts of interest in CPD, just to make sure that they're kept busy. And once you get through that interview, then you put on to the panel. And every 5 years, you need to be reassessed. And that's basically how it works. That first adjudication panel that I set up shortly after I attended here, I think there's only 3 or 4 of them now still on the panel. The rest have moved on, and we've got new adjudicators. And I'd encourage anybody who's really interested to persist. Network. You know, get in with other adjudicators. Join the Adjudication Society. That's a good thing to do. If you know adjudicators, ask adjudicators if you can kind of be mentored by them, if you like, but also sit and observe. I've done a lot of that in arbitration, in litigation, mediations. Watching, practicing, experienced adjudicators is a good way to really learn how to do it, and also, dare I say, how not to do it. If anybody wants to, who put up the hand earlier and said I'm an aspiring adjudicator, wants to have a telephone call with me or a chat with me anytime, feel free.
I'm going to take questions from the front now, if I may. And Paresh, was there any questions? Were there any questions? Any questions online?
None at the moment, no.
There was a chat. There was one chat. Is that a chat or is that a question? Look at the chat box. There was one. I could see there was a one.
No, nothing at the moment.
And nothing again. Right. Questions, everybody. Right. Paul.
What makes a good not arbitrator, adjudicator? I mean, I think there are a number of issues. What qualifications does he need technically, he or she, sorry, need technically? I'm building surveyor. This is very much QS territory because we're talking about disputes and you're talking about money, a quantum. That's the one thing I hate putting prices on. Yeah, so that's the technical side. What background do they need? Yeah, and then character. I mean, should they have a sense of justice? I mean, you know, a natural sense of justice. I've read Plato's Republic. I don't know if that could be advised. Obviously, I know something about the law.
If we need to know Plato's Republic, I think that would get rid of
all
most of the
about
people on the
justice. What is
panels.
justice? Yeah.
Not much
I mean, so yes, paint a picture of what you're looking for.
Yeah, I think first of all, an adjudicator needs to be credible. You've got 2 people who are involved in a dispute, and you as an adjudicator, the person who's going to decide that dispute. Paul Jensen, who knows Paul Jensen?
No.
Paul Jensen was my mentor. Paul Jensen's a wretched man because it was him that made me go into law, and he wouldn't let go. And I remember having done my law degree. I'm very pleased with it. I did actually did a dissertation on adjudication, got a first for it, and then met the wretched man a short time later, and he wouldn't let go until I joined the course, did the bar course. The reason I mentioned Paul is that he and I were having lunch together the other day about adjudicators, about the qualities of adjudication. And the important thing is you have to be a credible person, because you're deciding. He said an adjudicator is, in a dispute, is a very important person, because he is deciding something that these parties find very important, which is money. So the adjudicator has to be credible, has to be a subject matter expert, whatever it is that they're arguing about, has to be able to understand it and not have to have things explained to them over and over again. And yes, there's that thing that's, it's a theory, you can't really put your finger on it. They have to sometimes have that sort of authoritative demeanor about them. You know, that there's a quality about good adjudicators. And, you know, to be able to listen. And also, I haven't come across a good adjudicator who can't write a decision. You know, but have to be able to write a decision that says, this is what these two are arguing about. These are the key issues. This is the evidence they put to me, and this is the answer. And then it's enforceable. There's a lot of qualities, but certainly, you know, being able to write a decision is important.
So just following from what you just said, it says that essentially, so when you do the RSS diploma, the culmination of that, as you know, obviously is writing a decision. So
Yeah,
that's probably why, yeah.
all the skills you learn, you know, you learn about jurisdiction, you learn about conflicts of interest, you learn about how to deal with contractual matters, you learn how to deal with evidence, you learn how to manage process and timetables. And then right at the end, you have to bring all of that together and write a decision. And if you can't write a decision, then you're not there. So it's hugely important. It all comes to that point. Yeah.
Got a question online. Do you have to be an RICS member to get on the panel? It says I'm a architect and a barrister who's done the RICS diploma. Am I wasting my time? And then he's followed up. He says I'm on 3 other panels and decided adjudications for more than 10 years.
The answer to the question, do you have to be a member of RSS to be on the RSS panel, is no, you don't. And the reason for that mainly is that we are occasionally asked to appoint adjudicators, but the nature of the issues that need to be resolved are non-surveying. You know, sometimes they are to do with legal interpretation. So the answer is no, you don't. And yeah, I can understand this gentleman's frustration, you know, having to, you know, push himself forward to get onto the RSS panel. Just keep trying, but also, you know, talk to some of the adjudicators who are on the RSS panel, get a sense from them about how they got on in the first place, I think. And again, you know, I'm holding myself open to have chats with people. I'm really worried about this now, because I think I'm going to spend quite a long time on the telephone to people, aren't I? But the offer's there, and it's genuine.
Other question?
How do adjudicators determine their fees? That seems to vary.
I'm going to
with the
repeat it.
RSS.
I'm going to repeat it for the benefit of the people online who might not hear this, because the microphone's down the front. So how do adjudicators determine the
Fees.
size of their fees?
Yes,
Yeah.
they seem to vary even by the RSS.
There you go, Mark. There's one for you.
Well, obviously, not on the low value. I'm not on the low value one, by the way, but on the ordinary main panel, obviously, adjudicators will charge by an hourly rate. I don't think there's anybody who's less than about 200 quid now. And most of them are, unless you go to Texa, you're probably talking up to about 350. There are 1 or 2 adjudicators, particularly if they're partners on the Texa scheme, although there's a limit on how much they can charge per hour, who may wish to try and get more than that. But you're talking between 200 and 300 quid, I would have said, was the average. And I noticed that the LVD says no more than 250. But then it comes down to literally the number of hours that are spent. And you have certain adjudicators, some of the more experienced ones, and I can think of certain very bullish ones who come from Norfolk, and I think you know who we're talking about, who will go out of their way to make sure that they'd have no more than 3 submissions. a referral, a response, and then a reply, which is going to be replying only to the new matters in the reply, in the response rather. And it's very difficult to get a rejoinder or a surrejoinder through that particular person. And so one or two of the more experienced adjudicators say, well, our fees are high per hour, but the number of hours we charge are far less because we don't stand for any rubbish. And they will actually bully the parties. And I've seen this because I've seen some of their decisions. And then it just comes down to hourly rates. So it's, and you hope that you're going to get people who are not going to mess about. They're going to comply with paragraph 12 of the scheme. They're going to make sure that they don't spend any costs unnecessarily, and then they're going to keep an eye on it. And what I would say practically, having been doing this for God knows how many years now, is you probably don't charge all the hours you spend. You end up doing research, you end up reading cases. Okay, you should look at the cases that are put in front of you, but you might wish to ask the parties to address you on something. So you end up doing quite a lot of work, but then most of us will take that on the chin and not charge for it. And it then becomes literally a product of the hourly rate times the hours. And I think nearly every adjudicator I speak to, despite the size of the fees that you see us charging, will probably round it down rather than up. And they'll spend a lot more hours than they actually charge for. And that's the honest truth. But because we want ultimately for the decision to be credible and for it to be followable. And we've also got over our shoulder that if it goes to court, we don't want to be criticised by a judge. So we want it to be a good decision. Does that answer your question?
Yes, it's just, I'm trying to get in my own head why the fees vary, because the adjudicator is appointed based on a notice. He hasn't probably seen the referral yet, but he's appointed on a notice, and he probably looks at the notice and says, this looks like a case of X, Y, Z, you know, it will have a dispute in it, or what will make it a dispute. I'm just on that the adjudicator fees do seem to vary, have an experience of why the different fees. On one of the RSS, they have some parameters in terms of how they determine.
May I answer?
Please.
Well, on the low value scheme, you're looking at a sort of folder of documentation, whereas a case where they say the case is in the wheelbarrow is where the fees go astronomically out of the window. So if you're searching for the case, because that's the paperwork that you've been given by the both parties, then the fees are going to be extraordinary.
Can I just chip in a bit here?
No, you're the speaker. You definitely. Section 13, take power of the procedure.
The act of the scheme says that the fees of the adjudicator need to be reasonable. Adjudicator is entitled to a reasonable fee.
Yeah.
What it doesn't say, it doesn't define reasonable. Now, RSS doesn't have the power in those circumstances to set the fees for adjudicators generally. But RSS is very conscious that what it's providing is a dispute resolution service and not a dispute resolution bandwagon. So there's a couple of things here. One, if there is a suggestion that a particular adjudicator, for example, is overcharging on a regular basis, then RSS would need to know that, because it's only at that point that RSS could talk to the adjudicator and ask the adjudicator to moderate, because we're getting a lot of feedback, complaints, whatever you want to call it, about their fee scales. When we were involved in helping the government with its consultation back in 2017 on the costs of adjudication, it was remarkable that they produced evidence to suggest that the main concern wasn't really about adjudicators' fees, that the costs of adjudication that seemed to be ramping up tended to be fees paid to party representatives, lawyers, some who were alleged to be eking it out, to making it more complicated than it needed to be. And also some of the, and this is feedback informally from the government department base at the time, that the parties themselves were sometimes guilty of making the adjudication more costly, because it was them who were asking, oh, we need more time, I'm going on holiday, you know, knowing that they probably knew they were going on holiday and it was halfway through an adjudication. But that's just a bad example, I suppose, but it's an example all the same. It's not just a criticism of adjudicators' fees. In fact, there was little criticism of adjudicators' fees generally, though some, of course, were picked out
Martin, there's another question online. Disputes over 100,000 are negotiable. How are these negotiated and ultimately agreed between parties? And it sounds like a potential dispute in itself.
No, well, it's the adjudicator. It's just the adjudicator needs to set its fee scales commensurate with the dispute in front of them, a reasonable fee, and set it out. And it's not. I suppose negotiable is the wrong word. And I'm glad you've pointed that out, because as I said, I'm involved now in a working party. It's going to look at guidance, so we need to explain what that means. But essentially, it means that the adjudicator needs to look at what's in front of them and come up with a fee scale that is suitable for that particular dispute. And as Mark has said, most adjudicators charge an hourly rate. And so what they really need to determine is, if I can't resolve this within the amount of hours that would be, commensurate with a £5,000 fee, we're probably looking at an extra, I don't know, 10 hours, 20 hours.
So on the low value disputes, because on normal adjudications, you can kind of see what you're dealing with, and then they chuck in their jurisdiction challenges, the lawyers get involved, and kind of that can be a big element of fees. How do you kind of manage that on the low value side of things?
Well, if it's a jurisdictional challenge and it's got some merit, then the thing about jurisdictional challenge, of course, the adjudicator can't make a decision on that. But if that's going to take up time, then that's the adjudicator's decision. Well, because of that, does this dispute lend itself to being resolved through this quick process? So it's a judgment call. There's a lot of burden, I know, on the adjudicators.
Right at the back, and then I'll come to the guy in the middle, right at the back corner. You might have to shout a bit.
Okay, I will shout. Go back to fees. When is the fee actually paid? Is it on referral, or is it on decision, or any point?
The question is, when a fee is paid, is it on referral or on decision? So Martin, you want to take that?
You're the adjudicator. When do you get that?
Okay, so the nomination fee will be paid up front. So regardless if you're on the low value or the JCT homeowners or the RICS's main panel or the CIR panel, then all of those will charge a fee. The UK Adjudicators, I think, is probably the only one that doesn't charge a fee. And so the nomination fee is payable on application. And unless both parties agree, it's not recoverable as a recoverable head of cost under the decision of the adjudicator. As to the adjudicator's decision, well, until the adjudicator finishes his or her decision, they haven't performed the contract, and therefore they haven't got anything that they can charge. Although you occasionally see to this day adjudicators writing in that they want appointment fees and they want money on account and all of that stuff that I actually believe they're not entitled to. So the answer is, when you have made a decision, you have completed your job, and then you are entitled to be paid. And in my case, I asked for it to be paid within 7 days.
And if there's any arbitrators here, arbitrators will know that they have a statutory right to a lien, which means they don't have to release their decision until they're being paid. Adjudicators don't have that luxury.
Yeah, good point, Martin. So as an adjudicator, I can hold on to my decision until you pay me.
As an arbitrator.
As an arbitrator, so as an arbitrator under the 1996 Act, I can hold on to my decision. But it's specifically written that you can't do that. The adjudicator has no power to do such a thing. Lots of arbitrators who became adjudicators still used to write that into the terms and conditions, but it's unenforceable. If they don't deliver it within the 28 days or immediately close thereto, they won't have performed their contract and they're not entitled to anything.
From a practical point of view, it's very common for adjudicator staff to chase their fees. So it's a reality. So why would you want to be an adjudicator? Well, obviously they get paid sometimes, so it's worth it.
Most of the time. Yeah. Paul. Oh, sorry. No, there was a guy in between, wasn't it? Sorry, I beg your pardon.
I apologise. I'm worried we're getting fee heavy here with these questions. But the 250, when the rollout in May, I think I was at that rollout. You were there with Matt.
Yes.
There was some existing experienced adjudicators in the crowd who seemed to not like the fact that this was going to be what they described as a pay cut. I mean, I'm experienced with adjudicators fees, which I'll be honest is less than 10 adjudications, but I have seen none less than 350 an hour.
Really?
Yeah. So the cap of I've seen, yeah, I mean, I've seen.
You know, when you said about you don't see adjudicators' names written into the contract.
Mhm.
Well, I'd be perfectly happy to have my name written in for less than 350, but we can discuss that at the bar. Sorry, anyway.
Sure, but yeah, so I'm just interested in terms of, because you must speak to lots of adjudicators. I'm interested in people that, because people I would imagine who come on to low value panels, they're trying to get up onto the main panels and all this sort of stuff. So that 250 probably won't phase them. But for the people who may have been adjudicated for a long time, who may be used to a higher hourly rate, I'm just wondering how it's gone down with them, whether they're not interested in doing that type of work because they think, well, I can earn better money doing something else, you know.
Some are not.
Right.
What amazes me, in fact, I know a few very experienced adjudicators, been around since I was a boy, who are quite happy doing those things, even though they constantly complain to me that they're struggling to get paid, or they've spent far more hours adjudicating than it's worth, but they still do it. But there are those, and we can't make them, who have decided that they're not going to participate in the low value.
Is that because of the cap on the, just out of interest, is it because of the hourly rate cap and the overall cap?
You know, I haven't drilled down into why, you know, but you can make those assumptions, can't you?
So then come back to that.
Earlier this year, there was another scheme below the LVD, which was COVID related. Is that now gone?
So I better explain to the audience that this is what we call a summary adjudication.
I've forgotten what it was. Yes.
Yeah. During COVID, we were talking to Government Department Bays as well, and they were worried that a lot of small businesses would go out of business for want of very small sums indeed, you know, £3,000–4,000. So we set up an adjudication process that was even simpler. This is an RCS scheme, even simpler, which allowed parties to have disputes decided within 14 days, next to nothing, through the proper adjudication process. And it was designed to be implemented during this crisis, you know, the COVID crisis, when a lot of businesses were having difficulties with cash flow. The thing is, it still exists, and in fact, people are still applying for it. We haven't abandoned it as yet. And also, I've used it as a model for the which consumer adjudication.
I'm going to take a last question because I'm conscious that an alarm went off, which was obviously telling us that we're all, you know, past our sell-by date. So it's now just gone 8 o'clock. Paul, and then I'll finish. Okay.
Yeah.
You be a quick one, Paul.
Yeah, that's pretty brief. What happens if one of the parties does not comply to the time restraints? I mean, what powers do you have to overrule, or can you enforce them to do it? Does it ever happen? I don't know.
Oh God.
Yeah.
Well, you know, it's the adjudicator is the master of the timetable, master of the schedule. It really depends, you know, do they have a real reason or excuse? And should the adjudicator allow them? You know, we've had cases where somebody's fallen seriously ill, for example. But there have been times as well where they've just been recalcitrant and the adjudicators decided to get on with it. Give them the opportunity, but the adjudicator doesn't have to wait forever for them to participate. And the adjudicator makes the decision, gets on with it, and has to make the decision within the 28 days, unless they've been given that extra time.
And it goes to the weight that they place upon it. So if parties start playing silly bees, and they want to try and submit more evidence and more evidence and more evidence, well, it's up to you. You've got to be seen to have, you know, considered the evidence, but it's the weight you place on it, given that your overall job is to make a decision within the 28 days. So you know, this is part and parcel of the procedures that you learn. And as long as you can show that you considered everything and didn't reject stuff, then it's going to be an enforceable decision, or it's likely to be.